What's up, guys? Welcome in, everybody. Happy Tuesday, y'all. Give folks a sec to pile in here. What's up? What's up? There he is.
Hey, how's it going?
How you doing, brother?
Good.
Did you? I know usually, Brian, when you jump in, I think I end up driving the slides for you. But maybe if you want to, while people are piling in, maybe if you want to try and test.
Let's see what happens.
Yeah.
Is there a way to? Let me see.
You should have the share button at the bottom down there. What I found that works easiest, Brian, is if you keep the presentation open in the same window as Ask Kajabi, but you can try and play around with it. Cool. While Brian's working on that, what's up, Alpha Host fam? Happy Tuesday night to everybody. I think we skipped 2 weeks, maybe a week. I don't know. It feels like a long time. We had our Inner Circle event last week. There we go, Brian. I can see that.
Cool.
Yeah, and then we had an Inner Circle event last week, so I know we were a little out of pocket, but excited to kind of get back into the swing of things here. Cool. Yeah, that's kind of just fine. We see the I think right now we see the speaker, or you didn't start the presentation. That's fine. Good for us. Cool. Awesome, guys. Well, let's kick it off the way that we usually do. Let's get some wins going on here. I think I can start on mine and Sarah's side. We went down to Utah. Oh, that's why we were gone, because we were in Utah the week before the Inner Circle. But Sarah and I went down to Utah. We had to fire our innkeeper, who had been with us for, I don't know, maybe 8 weeks. He was just not working out. Anyway, we had to let him go. But the same reason we went down there was because we were onboarding our new innkeepers, and it has been a world of a difference. And our hope is that there's someone that we can stay with long term as we kind of stabilize that property. So big win for us on the people side. They are our 4th innkeeper since we launched back in the springtime. So hoping we get some stability in. So that's a win for us. We got some good people coming into Utah. Who else? Give me some wins, big or small. Big wins or small wins. I need at least one before we jump in here with Mr. Bradley.
On that note, Tony, I fired my first cleaner also.
We'll take that as a win, man. There you go. Congratulations.
Yeah.
Which property was that for, George?
That was for the Hocking Hill.
Gotcha. Okay.
Yeah. It at the beginning she was very helpful, but then her cleaning it's gone bad so badly that I kept on getting complaints about dirtiness and not very clean. So
yeah.
I was trying to hold on to her, but then I was just like, you know what? I gotta cut my loss.
Yeah. Well, kudos to you, man, for having the guts to cut a cleaner you've been with for a while. We did a very similar thing 2 months ago in Tennessee. So the first cleaner we ever hired, we ended up letting her go. Same thing, man. Just like the attention to detail wasn't there. As our business kind of grew and expanded and our systems and processes changed, she didn't want to change with us. So, hey, man, as the business grows, you gotta make sure that you keep the right people around you. And sometimes it means letting go of the ones you started with, but opens you up to finding someone better, man. So kudos to you, man. We'll take that as a win. Not that this call is supposed to be about firing people today. That's not what
it is a win for me. So
yeah, we'll still take it as a win.
Yeah.
Cool, guys. Give me one more win, big or small.
We launched our new Airbnb.
Boom! There you go. Congratulations. That is a win for sure.
Thank you. It's our 4th.
So is the garage got that project taken care of? It's all.
No, that's not yet. No, it's a new one. It's absolutely new. It's in Broken Bow.
Okay.
So we just got new market, and we're in a track to close in a week or 2 for the new Honolulu one. So that will be our 5th.
Keep him busy. I love it.
Should be up to 5 at the end of this year.
Keep him busy.
One can hope.
Yeah.
We are busy for sure.
I love
Thank
that.
you.
Congratulations.
Thank you.
Cool, guys. We'll take that as a win, and we'll jump in here. So, guys, we talk probably about once a quarter. We bring Brian on to kind of talk about the asset protection side of building your real estate business. And as you guys know, Sarah and I, we are real estate investors. We are not tax professionals. We are not attorneys. So we do our best to bring those experts on to talk about those topics. So I think it was 2 or 3 weeks ago, we had Amanda Hahn and Matt McFarland on talking about the tax side. And now today we have Brian Bradley on to talk about the asset protection side. So I will turn it over to Brian. Brother, thank you again for jumping on with us later in the evening. I'll be here hanging out. Again, guys, if you have questions as we're going through, put them in the chat. And Brian, if there's any questions that kind of pop up as we're going through, I'll keep an eye on the chat and I'll kind of direct you. But
Yeah,
otherwise, we'll kind of grab them at the end here.
sounds good. Beautiful. You want me to just get going?
Yeah, go ahead and jump in whenever you're ready, brother.
All right. Yeah. So thanks, guys. And thanks, Tony, for, putting this together again. And some of you might have heard me, before talking to this group, and some of you might be new to the group and the whole asset protection world. And so I'll try to not make it like so much repetitive for, if you've been here before. But again, like I'm Brian Bradley. I'm an asset protection attorney. And I focus on high risk individuals, which a lot of that comes down to, either like doctors investing in real estate or real estate investors like most of you are. And so if you're in this webinar today, I'm pretty sure this is going to affect you as you are trying to reach that, financial freedom and investing and building those properties. And you're probably really passionate about the opportunities that life brings you. And so at the end of the day, it just comes down to, we got to protect it and keep it, right? And so that's what asset protection is really about. And so today I'm going to quickly just try to summarize and talk about modern day asset protection planning, because we find ourselves living in just increasingly unpredictable times in a divided world where sadly over the past 3 or 4 decades, the legal battles threaten to take our hard-earned wealth. And so we're always constantly asking ourselves the same question, is this game still winnable? Everything seems so rigged. Can we keep our wealth and our financial freedom safe? And the answer is yes, but how we do it is really important. And I actually just had about an hour before I jumped on here, a call with the person calling in, and they had about 20 rental properties, and one of the rental properties was next to a school, and one of the tenants there has been slinging drugs out of the property, and now he's entwined in this massive lawsuit. And so it just goes to the importance of, even if you're, the greatest person in the world, you never know who you're renting to and what's going on really behind closed doors in your properties. And so this, just a real life, story of why it's important to set up the asset protection hand beforehand. And again, just a little bit about me. I'm the senior managing partner of Bradley Legal Corp, advisory board member to the Asset Protection Council. I'm also co-counsel of other firms like Lodmill. And then I'm the author of the #1 best-selling book here on asset protection called Overexposed. This book breaks down everything that I'm going to quickly try to run down on asset protection, just in a lot more detail, in an easy way to read with a lot of case law examples. And so I recommend, don't try to memorize what I'm saying. You don't need to crash notes. Just, listen to it, understand the theories and concepts, and then rewatch this presentation if you want to. And, the book will really help break down the concepts that we're going to be talking about. And again, the hope is that these key concepts help you make a plan and take the preventative steps to protect yourselves. And as you're going to quickly learn, it's going to be what we do beforehand that is really going to matter. And, before we get to the tools that we're going to use to fight all this chaos and craziness, we really just need to understand a little bit about the world that we're living in and why it's really important. And so if we set the scene right, we've been living in it, especially the last 4 years. If we look around, the legal system's just broken. It's a joke. Same with our financial system. If we turn on the news, it's plain and simple. It's in our face. They don't even try to hide it anymore. We're living in just a completely sue-happy nirvana where nothing is anybody's fault. And we've legislated away accountability and responsibility. And so at the end of the day, the idea is, in this crazy cultural shift of this predatory legal system that's just about profits now and increasing the size of a victim class, what are we going to do to protect our assets? What is asset protection? And when does it even have to be set up? And I really want to start there because that's the pivotal point in time. Like, one, let's identify what's this crazy word, right? Like, what is asset protection? And so asset protection is simply creating a legal barrier between your assets and the person suing you before it's needed. It's honestly, it's that simple. It's just a barrier, like a safe that you want to put your valuables, like your gold and your guns and your jewelry in, your intellectual property in, your equipment, land, rentals, all that stuff. Anything of value we want to put behind the legal barrier and out of your personal name so that it's not easily attached with a lien. Like, we don't want to own things in our personal name. Instead, our asset protection trust, do our business entities own it? It's just like we want to copy the rich, right? The rich don't own things. They just get the beneficial use and enjoyment from them. So what is the role of asset protection? Again, it's simple. It's peace of mind and lifestyle preservation. You want less stress knowing your finances and your assets are safe no matter what the situation is. And sadly, right, the deal that falls apart, the contract that's breached, the wrongful termination or harassment claim, the partnership that falls apart. And honestly, like, sadly, most of them do. And that's where some of the biggest lawsuits actually come from, are just like deals and partnerships that fall apart. The investment or tax filing that we recommend, if you're like a CPA or in the financial world and it didn't pan out and now the client blames you. This is a common one, someone being drunk on your Airbnb or short-term rental, and they end up getting hurt and they decide to blame you and sue you. Or if you're in the medical field, right, a patient that sadly dies on your table, or there's environmental and climate changes, workforce issues that most people don't think about if your business owner's getting sued. I did a lot of employment and labor law trial work back in California when I was a trial lawyer. Those were like, really easy pickings. Mold issues are another massive one. And so all these things are just like ways that we can get sued, and the reason why we got to be in front of this beforehand. And this next part's really important, and I spend a lot of time talking about this. And what asset protection is not. And I say this over and over and over again, and I still get these calls all the time. Asset protection is not hiding money or moving assets to not pay or avoid paying taxes, or to hide assets from your spouse because you want to get in a divorce. All right. All that's illegal. You're taxed on your worldwide income if you're a US resident. Even if you're like Elon Musk and we're, mining asteroids in space and we make $1 trillion in space mining asteroids, you're still going to be, taxed from your asteroid space mining program here in the US, because we're taxing our worldwide income. And the big takeaways really from this talk, if you get nothing else from it, is that asset protection is not to avoid paying taxes, and it has to be done before you're being sued. All right. Like, big keyword there, before you are being sued. And I talk about the timing of creating an asset protection plan in my book, Overexposed, a lot, because this is actually the critical stage for an asset protection plan to even be effective and work. Think about it like trying to go get car insurance after you got in a car accident, or house insurance to cover the fire after the house burnt down. Like, it's just not happening. The same thing applies in the world of lawsuits and asset protection, and is demonstrated really well in a 2010 case called SEC versus Lolo. Here's a case where the wife's trust got attacked by the SEC to try to get money back from the husband because he was engaged in just fraudulent trading schemes. So just a bad guy doing bad things. And the court found that he made fraudulent transfers after the SEC judgment was entered against him. So what he did was he signed assets over into his wife's trust to protect them after the judgment. And this is just straight up fraud. And it goes even before that. It's just not even a matter of a judgment being entered against you. It actually goes to foreseeability of being sued. So even before you're getting sued, the court is going to say, well, Tony, you did something that is foreseeable down the line that you're going to get sued from that. And so that's when we start worrying about the issue of fraud and fraudulent transfers. So that's why it's so important to make sure, if you're even going to start creating an asset protection plan, do it when it's not relevant and not important. Like when you're at peace and your castle is not being attacked. We're not at war. Everything's nice and calm. This is the time legally for it to be best for you to start creating your asset protection plan. So Mr. Solo, he was held in contempt of court, But, and this is a really big but here, 100% of his assets were protected. Why? Like, this sounds really crazy. And I use this case to demonstrate two things at the same time. One is just the power of an offshore trust, which I'm going to talk about in a little bit later. And though Mr. Solo was blatantly wrong, his assets were completely safe. The SEC couldn't get to them. And so what that means, one, is that his asset protection trust, it worked. That's point number one. But the negative, the sad thing is that he was held in contempt of court. But why? What did he do wrong? The second point in this case goes to the timing of setting up an asset protection trust. Again, he transferred the assets too late. He was late to the game. He did this after the fact, after it was foreseeable, after the lawsuit, after the judgment, and that was fraudulent. And then that opened up the door for the court to hold him in contempt of court. And it didn't matter that it was a foreign trust. It was the acts that he did this after the fact that brought that issue on. So the big takeaway is that the planning has to be set up before the lawsuit, not after the fact. But you have, no idea, again, how many people call me after they hear me ranting and raving about this and saying, like, I heard you talk on X and Y and Z. I don't want to pay taxes, or, I'm getting sued now. What can you do so I can avoid a judgment? Nothing. There's literally nothing anyone can do for you. And just realize if someone tells you that they can do something for you after the fact, ask for the case law, and then just realize that they're just selling you a bag of tricks that's not going to work for you. Let's go to the next one. So let's start breaking down the world of asset protection, right? There's two big ones. There's either exemption planning and asset protection planning using like LLCs and asset protection trusts and limited partnerships. What exemption planning refers to is the type of protection that we get just from like state and federal laws and statutes that just exempt specific types of assets from creditors. The creditor is valid, the lawsuit is valid, the claim is valid, the judgment is valid, but just these specific assets are just something that they cannot be collected on. And we have just common examples that we know of from life, right? Homestead exemptions if you live in Florida and Texas, ERISA 401k plans, which are federally protected, IRA plans, which are state protected, so they're going to vary state from state. Same with life insurance and annuities, and then some assets through bankruptcy, right? So one thing, I want to make a point of is like buying gold is not asset protection. Buying gems is not asset protection. Investing in digital cryptocurrencies is not asset protection. They're all different types of asset classes, right? Like buying property, but we still have to protect those from lawsuits because they're not exempt assets. Now, asset protection planning is completely different. It does not rely on state or federal statute to say like, hey, these are specifically exempt assets, we can't touch them. It uses legal tools to limit the access of the assets from a creditor. And these are like spendthrift asset protection trust, charging order protection entities like LLCs and limited partnerships, or locked up and unreachable assets. Like, for example, you just bought a property and it is just like smothered in debt. It's really worth nothing. Then there's no money there, right? Like if you have nothing, there is nothing for someone to get from you. So just a lot of debt is another form of asset protection, but it has to be legal debt, like going and getting a friendly lien under, subpar margins that not at fair market value, equity stripping like that, and friendly liens is considered fraud. It actually doesn't work, but you hear people talk about it all the time. So you're going to be asking like, okay, Brian, which is better, exemption planning or asset protection planning? And you may be looking at exemption status planning and thinking like, dang, that looks pretty darn good. So why can't I just do exemption planning all the time on everything? Well, the drawback with exemption planning is that it can't just be arbitrarily expanded, right? Like we can't just say, okay, great, our state has all these exemptions, so let's just move or transfer all of our assets into them. And it's really hard to convert 100% of a client's assets. It's actually hard to convert just 40% of it because it has to go through like actuarial equations. And remember, the list of exemptions are actually really short. So we end up having to do additional planning, right? That's called asset protection. The best practice on this would be to maximize exemption planning first, right? Like investing in your 401ks, and then moving on to asset protection planning for the rest of your exposed assets, like your home, if you're not in like, Florida or Texas, or for your rental properties and stocks and bonds and exposed assets, syndication shares and stuff like that. So we need to put them somewhere to protect them. So the modern wealth destroyers, they're no longer death taxes, right? But predatory lawsuits, our broken legal system, divorces, and just out of control medical costs. These are your modern day wealth destroyers, right? It's not death taxes. And remember that solo case that I was talking about, the system, again, it has to be set up beforehand to even try to fight all of this. And so when clients call us, we know that they want 4 things. They want an effective plan. They want to control their assets in the plan. They want reasonable and sustainable costs. Like if you can't afford it, you're not going to do it. And you want a plan that's actually going to be easy to maintain compliance with the IRS on. Like you can create the most beautiful piece of, asset protection planning, but if it is so convoluted for you and your CPA to actually file the taxes on it every year, after about 2 years, you're just going to let it go and it's going to completely not work for you anymore. So when we evaluate different tools and structures, this is the measuring stick that you want to be using. Like how many of these boxes can we check off? Or what are we sacrificing and why? So just think of it as like ECCC, effectiveness, cost, control, compliance, whenever we're working with asset protection plans. And so here's where I want to go. I want to just quickly break down the tools that we use. Then I want to throw them all back together again and kind of show you how we build it up over time. So when it comes to asset protection, I want you all to think about winter, right? Like when we're dressing to go out on a cold winter day, like I grew up in Lake Tahoe in the snow. I live in Portland right now. It's already torrential downpour, like almost freezing right now. It's just a great place that we're at. Layers are our friends. The first layer that you put on is your base layer. So think of that thin shirt that sits on your skin. This is entry level 101. These are LLCs and insurance. So this is our entry level. You're just starting out. Maybe you have 0 to 1 or 2 properties. This is where we're at. And then as you start growing, we start adding more assets, more risk, maybe like you're a doctor or, some kind of high visible profession. We're going to need a thicker, shirt, a thicker sweater. There's going to be a sweatshirt for us guys, a cardigan for you ladies. This is in the asset protection world. They're going to be like limited partnerships or management companies. And then we're going to want an outer shell waterproof layer, right? Like we're at that $1 million mark now of exposed assets. This keeps you nice and dry and warm when the weather's really cold and bad. These are the big guns, the asset protection trust. But by layering, you're going to be now more flexible when you get hot in your skin, you can take the outer layer off or the inner layer off, the middle layer off. You can adjust and make yourself more comfortable. The same thing applies with your asset protection plan. We never want to be stuck in a corner because once we're there, we can't go back. So let's just start with LLCs. LLCs are a great first layer. Like I said, it's the foundation along with insurance. LLCs are great asset holding companies. They have some charging order protections, which what charging order protections are is they limit our creditors' access to assets to an extent, it separates personal and business liability, and it helps protect the rights of the LLC members, which are you. We place risky assets directly into LLCs. So think of them as like things that need keys, things that can go boom and have moving parts and motors, things that can just hurt people and that we need to get insurance for. For example, rental properties, planes, yachts. Those things are going to go directly into LLCs. By using LLCs, what we're doing is limiting some of your personal liability and separating out ownership, use, and control. But it's not where we end. As your assets start growing, your picture is going to start changing. Your asset protection plan needs to start adjusting with you. But what's not talked about is the cons of LLCs. And so the LLCs lack on efficiency. Of all things, they're just not that efficient. But like, honestly, this should not be a shock to anybody. They say it straight up in their name, first word, first letter, limited. They don't hide this fact. And somehow over the last few years, we were misled to believe that, LLCs are a dragon slayer. Just go get one LLC, stuff everything in it, and you're good to go. That is not the case. We have to remember that LLCs were created in the 70s with the goal of blending the elements of corporations and partnerships without the downside of taxation. Asset protection was actually never the end goal of LLCs. So by nature, they aren't the strongest strategy. And they're not a one-stop all fixed entity because they were never designed to be. And we have just a lot of confusion on where do we even set these things up in. Like basically, like think of jurisdictional shopping because we hear about like, oh, go to Wyoming, Delaware, Nevada. LLCs offer a limited veil of protection. That veil's better than nothing, but it's fragile and it can be easily pierced. Just think of them like that thin, flimsy piece of fabric that covers the face of a bride on her wedding day. So it really just comes down to an issue of what are you holding and where are you holding it at, especially if we're talking about real estate. Jurisdictional shopping when it comes to LLCs as holding companies for real estate doesn't work. And so let's say it's California real estate, and I'm just going to use California consistently as an example because I just enjoy picking on the state of California. But let's say it's California real estate that you own and you're a California resident and you set up a Wyoming LLC. And then you hold a key piece of California real estate in this Wyoming LLC. And you're paying California franchise tax on this out-of-state Wyoming LLC. What you've done is just convert your Wyoming LLC to a California LLC because you're doing business in the state of California and you're paying the franchise tax in California. And you're legally required to register that Wyoming LLC in the state of California. But if you ever have a liability issue in California, meaning like a lawsuit, you're getting sued, the judge in California is going to apply California law, not Wyoming law. And this is just basic jurisdictional law 101 because there's no legal nexus between the two states. And we can sub out like California with like Tennessee or Michigan or any other state. I'm just using it generically as an example. And this is demonstrated actually in a 2023 Supreme Court case named Mallory versus Norfolk, where the Supreme Court upheld a Pennsylvania statute. And this is really important. It forces companies to face litigation within the borders that is registered to do business in. And remember, you're legally required to register your out-of-state LLCs in the states that you're doing business in. So I'm going to say it again. It forces companies to face litigation within the borders that is registered to do business in. So running off to these other states, you're not going to get any benefit from it. And so this case now opens the door for other states to adopt similar registration requirements. So state courts are permitted to exercise jurisdiction over registered foreign corporations. That's really important for you to know. You can't just go and take Wyoming or Delaware tort and damage and personal injury laws with you to other states. You can't just go and purchase another state's more beneficial laws. So we typically just say use an LLC in the state that the asset is owned in. So if the asset's in California, California, Tennessee, Tennessee, Florida, Florida. And this next distinction is really important. You see, sadly, what people don't realize is that, protecting real estate is just different. And they confuse business law and contract law with tort law and personal injury law. When like Tony and I are setting up a business to sell widgets, yeah, we can incorporate in Nevada or Delaware or Wyoming and use those state provisions to govern internal disputes and affairs of the business. But again, when it comes to real estate and LLCs acting as holding companies for rental properties, that's what we're creating them for, that is not a business. So when a person gets injured on your property and sues your LLC or sues you personally for damages due to wrongful doings and negligence, that is not a business dispute. That is a tort liability. And tort liabilities do not relate to internal affairs of the business, right? They're outside the entity. So you really do not have corporate veil protection from that. Now, there's going to be
Just one good question. So if you can go back on that slide, like we've talked about S corps being bad from a tax perspective, but from if you can just maybe specify specifically that there.
Yeah, thanks. I try to limit certain things based off of time, and this is actually really important. And I get this a lot. People coming and utilizing S corps to hold their real estate, and that's a big no-no. It's not good. And the reason is, and I generally get this from somebody who is saying hey, I talked to my CPA and I bought some real estate, investing in real estate. And for tax purposes, the CPA created an S corp and we stuffed all of our real estate into that. And then next thing you know, over 10 or 15 years, they create a $20 million real estate portfolio in one S corp, one company. Well, the S corp's overstuffed, right? Shoot, I have 10 properties in one business entity. What happens if I get sued? They start realizing everything's exposed. That's not good. Here's the problem with S corps. One, S corps have shares, and those shares can be frozen, seized by a judge, right? So now everything's at risk no matter what. Two, if you're getting sued or we got to move the assets out, we cannot move assets out of an S corp without you owing the deferred taxation back. And most people don't have that type of liquid cash just sitting around. So what ends up happening is the assets are just frozen and stuck in the S corp. So we never want to use S corps as asset protection structures, especially for holding real estate. What we want to do is hold the assets in LLCs and have that connected to the asset protection structure. You can always create an S corp if you really want, or maybe like I would prefer to go a different route, like a C corp as a operating company to have money coming in if you care about just like, the tax perspective, and then lease the properties back out if you want to do that. But I would not hold real estate or assets. Like, don't think of it just as real estate. I've had clients that own, multi-million dollars worth of moving truck beds, cars, you get a flat tire, like brain's not working on what that is, like tow trucks, and, millions of dollars worth of trucks, all in S corp. Same thing if like a doctor and they start holding all their equipment in S corps. That's the worst thing that you can do, because then all of your assets to operate and run your business are now going to be potentially jeopardized. Does that answer your question?
100%. I just wanted to stress that point because my CPAs have also told me, don't hold your real estate in an S corp, and to hear from the asset protection side. So just wanted to drive that point home for everyone on the call.
Yeah, no. And sadly, most CPAs will do exactly what you said. And then every now and then I would say like 2 out of 10, you'll get the contrary advice on it. And then they create a massive mess. So just realize, anyone listening to this, like tap the brakes on that and don't go with that situation. We already went over like the corporate veil. Again, it's just going to be, there's no litmus test like explaining when and how it's going to be pierced. But there is guidelines on this. It's through the famous case, Auckland Meat Company in 1962. And here, California generally leads on a lot of like cases just because of the sheer size of the state. And it's always generally ahead of what's going on. But the Court of Appeals provided a list of 20 reasons that justify piercing your veil. I'm not going to list all of them. These are the top 5 heavy hitters. Commingling funds, using funds for something other than corporate uses, failure to maintain adequate and corporate records. That's almost everybody. The use of a corporation as a mere shell, probably a lot of people. Undercapitalization, the most vague term of all in the legal world. And most people get pierced from that. And so I'm pretty sure if you're investing or you have LLCs or business entities, you probably checked off 2 to 3 of those boxes, and that's just 5 of them. And then it's even riskier if we're going to be using single member LLCs. Courts can and do disregard the charging order protections of single member LLCs. We have the famous Florida Olmstead case along with MDY Industries case. I break those down a lot in my book. So I would read into those. They're pretty interesting cases. And so through this journey here, just on the case law of LLCs, I hope that you're able to see the problem here. Yes, we use LLCs, but LLCs are limited and they can be disregarded, and then the veils can be easily pierced. And insurance doesn't cover everything. And even if you have an umbrella policy, it just adds more capital to fight. And I've even seen cases now where the umbrella policy insurance holder agency actually wants the money back. It was with a doctor that called in recently, and he was getting sued for a medical malpractice case where he was getting sued for $4 million. He had $2 million in medical malpractice coverage and then $2 million in an umbrella policy. So the medical malpractice coverage covered their $2 million. The umbrella policy company said like, yeah, sure, we'll cover you for the other $2 million. Changed their mind and decided to sue the doctor back to get the $2 million back because they wanted him to have insurance on top of the insurance on top of the umbrella insurance. It just started getting insane. And so this is why as you grow and your assets grow and your risk and your visibility grow, you need to start adding more layers of protection. I think this one's really important to go over. I can always like limit the limited partnership portion of it. It's the word that everybody's become enamored with is just anonymity. And the thought here is that you could just create like an anonymous Wyoming LLC, which I already talked about, and just poof, disappear and ghost a lawsuit. And this is just completely false. This is not online dating. The reality is that if you get a judgment against you and you get called into a debtor's examination in court, you are the weak link in this line of secrecy. Like under oath, you're going to have to tell them like, yeah, I set up that Wyoming LLC, and now your plan has just completely exploded in on itself. Privacy is fine. I like privacy, and we can get privacy from like limited partnerships and trust, but secrecy and hiding is not. The simple reality is that once a lawsuit is filed, the discovery of litigation begins, and you're going to be served, you're going to be subpoenaed, you will be forced into court. It's just the process of it. Anonymity then at that point in time is out the door. Anonymity is a privacy mechanism to avoid harassment from someone like saying, I know where my landlords live, I hate them, I'm going to go egg their house and harass them. That's it. It's not a ghosting a lawsuit mechanism. The other strike against anonymity recently is the Corporate Transparency Act, the CTA, reporting requirements that went into effect January of this year, requiring the reporting of beneficial ownership information of an individual owner of entities to FinCEN. FinCEN is the Financial Crimes Enforcement Network. And so, yeah, you still have some privacy because the CTA requirement to FinCEN, it's not public. But we need to remember that, again, anonymity is a privacy mechanism. It's not a protection mechanism. There's a way to get privacy, but we need to make sure the plan is efficient to actually protect you when you're getting sued.
Right. So let me ask, because you're right. I feel like that's a hot topic on social media. Everyone's like, oh, go open up this LLC in this state and then you're fine. So can you maybe just, like, the anonymity, at what point does that get broken? Because it's valuable up until a point, but what is that where it no longer matters?
Yeah, so it's valuable just from a privacy mechanism, like to avoid people knowing where you live and who owns it and what's the name on it. It completely goes out the door once the entity gets sued, because you can't just avoid a lawsuit. So your Wyoming LLC gets sued, and then the member of it is going to have to respond and show up in court. The lawsuit then is going to be amended at that point, and you're going to be added onto it. So you can't. People are getting this misconception that, oh, I have a Wyoming or Delaware anonymous LLC. No one can ever find me and discover me, and no one can ever sue me. That is not how anonymity works. It's just a privacy mechanism. Again, it's not a completely avoiding lawsuit mechanism. So once the LLC gets sued, anonymity is done. You're going to be in court, and then you're going to be forced to list all the assets that you own. And that's just the reality of how litigation and discovery works in court. Does that make sense?
Yeah, awesome. Thank you, Brian.
Yeah. Next, I would break down a lot like limited partnerships. I think it's more important to go into trust for time. Just realize we utilize limited partnerships as management companies instead of another LLC on top of it. And the reason for this is just the nature of limited partnerships. They're a better class of owners of management, because they think of limited partnerships as a split personality. You're splitting up on one side through the GP side, management of the assets, and on the other side, ownership of the actual assets. And that should be your trust. I want you to be the managing member, but what I want to actually own the limited partnerships and asset is your actual asset protection trust. And that's how we legally can split up management from ownership. You cannot do this with LLCs because they're not designed to. So some people might say, oh, we'll just get really creative with the operating agreement. And the issue with that is, like anything, if you start getting really crazy and creative with operating agreements, when you get sued, those operating agreements get presented to a judge. And a judge is going to decide if your operating agreement is a bunch of BS or if it complies with that state laws. And that's a really scary place to be. I don't want a judge determining if he's going to agree with my operating agreements. And so by utilizing the limited partnership, it takes that argument completely out of the way, because there's no other way to create a limited partnership other than this, because by statute, by design, you have to have a managing member and you have to have an owner, and they are completely separate from each other. And so this is why one of the reasons why we use limited partnerships. This right here is just showing how the structures over time start looking. Right here, where you have the risky assets down on the bottom in LLCs being disregarded and floating up into the limited partnership. That's going to start making it easy for your tax filing. So that way you just have one tax filing versus I have some clients with 50 LLCs, right? Like no one wants to be filing 50 K1s. So we can have them all float up into the management company, the limited partnership, one K1 issued to you. And it's just a one-page attachment called a 1065. And the limited partnership can start holding like non-risky assets, cash, stock, bonds, intellectual properties, things like that. And so there's a lot of benefits that I like out of utilizing the limited partnerships. And then this really is then going to start bringing us to the big guns, the world of asset protection trust. And I really want to spend a little bit of time breaking down trust because there's so much confusion in the world of trust because they're not really talked about. But contrary to belief, not all trusts are the same. For some reason, people think like, oh, well, I have an estate plan, a revocable living trust. I'm good to go. I have an asset protection trust because I have this revocable living trust. And that is the farthest thing from the truth. So think of trust like Baskin Robbins, right? Like the ice cream company. Trust comes in lots of different flavors and types, just like ice cream in 31 flavors. We've got the standard 101 trust that everybody's familiar with from the 60s. This is what I just mentioned, the family revocable living trust or the estate plan. And so they're designed to avoid probate, pass along your assets, get your medical directives, financial directives, but they are not designed to protect your assets. They don't have the teeth in them. They don't have the statutes in them. And then you also have what people hear from like a lot of investment shows, and you hear people talking about land trusts, right? For real estate that hold your land, and then we connect them to LLCs. But land trusts don't have any protection in and of themselves. They're only as strong as the LLC that they're connected to. So what land trusts are is they're just a privacy mechanism. They're not a protection mechanism. We also hear about Delaware statutory trust. These are more of a tax mitigation strategy specifically for California residents who want to try to avoid paying the $800 franchise tax. It's not really an asset protection strategy, but a tax mitigation strategy. And I think it's foolish to design an entire asset protection plan around avoiding paying franchise tax when you can potentially get sued and lose everything else. There's better ways to go about this. Same thing for irrevocable gift trusts or like generational wealth skipping trusts, like, and similar trusts doing the same thing, name something different. They're just tax mitigation strategies to decrease the taxable estate. So remember, when you start hearing people talk about like taxes and you're trying to talk about asset protection, those are like oil and water. They do not mix. And so we need to be really careful with that. Generally, if you're trying to incorporate tax mitigation strategies within your asset protection plan, it's going to then invite allegations of fraud. It's going to decrease how effective the plan actually works, and it's going to take away control. So you really do need to pick which side of the fence you want to fall on and realize, do I care more about protecting my assets if I get sued, or do I really just care about, saving on the tax side? Most advice will fall on protect it as strong as you can, and then have your CPA and your wealth managers work as much as they can within the system that's then protected. Because if you lose everything, there's nothing for your CPAs to work their magic on anyways. From here, we have higher levels of trust, and these are called asset protection trust. And so asset protection trust came into play in the early 1980s. And an asset protection trust is what's called a self-settled spendthrift trust. All self-settled means is that they are created for you, by you as your own beneficiary, and they have very important spendthrift provisions in them. These let you protect your assets while you're living. The difference between a revocable living trust like the family estate plan and an asset protection trust is that asset protection trusts include these critical spendthrift provisions. And it's these spendthrift provisions that are the actual teeth behind those trusts to protect your assets. And then for those teeth to actually work, the trust must not be revocable, but irrevocable. So it's a very different type of trust, just like chocolate and vanilla, right? Both ice cream, but just very different types of ice cream. So someone would then generally be asking like, okay, what's the difference between irrevocable and revocable? Now, the concept of irrevocability is really simple. Irrevocable means that once an action's done, it can't be undone. So for example, once you jump off a bridge, you're off, right? Like there's no undoing it. There's no coming back up unless we have a bungee cord. And so as a starting point for creating an irrevocable trust is just like jumping off a bridge. Once we create it, you can't revoke its purpose and its terms. They're fixed. No changes are allowed. It doesn't mean we can't move assets in and out and protect our assets, right? It just means, again, that its purpose and its terms are fixed. You're still going to be managing your assets and buying and selling things however you want. And it's possible to create a trust that is irrevocable, but still leaves room for flexibility to its terms. So what we're doing is just attaching a bungee cord to portions of the trust so that then we can then modify them later, known as flexible irrevocability. And the courts are completely fine with this. the next logical question would be like, Brian, why would I ever want to make an irrevocable decision? Well, it really just comes down to just what are your goals, right? Like with a traditional family will, like the revocable living trust, the estate plan. Yeah, you're absolutely correct. Keeping your options open is going to be very important. We change our minds a lot before we die. It makes complete sense to use a revocable instrument in that case. It's like a grandparent who's like, I'm going to leave all my kids to my, newborn, all my assets to my newborn grandson. And the next thing you know, cute Johnny becomes cocaine Johnny 22 years later and is off in Vegas all the time. Like, we're going to change our mind, right? We're not going to leave him $20 million. Now, on the other hand, if you want to reduce the size of your taxable estate, then using a revocable gift or a revocable trust will not work, since the tax code will ignore that gift because you can take it back, right? So you would have to use an irrevocable instrument at that point in time, like an irrevocable trust or an irrevocable gift. All right, so what about in the world of asset protection? Well, let's ask this question. Which type of planning do you think would stand up against an attack on your wealth in court? Something that's revocable and then can be changed, or something that's irrevocable? If you guessed irrevocable, you're completely right. For the same reason that that gift, which is revocable, is still considered by the IRS as yours, since you can take it back. So now we're starting to see the picture, right? Like, we're starting to see that there's different types of trust. Each is used for different situations. And some of them are revocable, some of them are irrevocable, some protect your assets, some dispose of your assets. And then it really comes down to, and I'll try to summarize this next section up, quick to not, spend too much time on it. But we have two trains of thought when it comes down to how to set up an asset protection trust. We can go international, like in the famous Cook Islands, or domestically here in the US. From a historical context, that international came first. In 1984 in the famous Cook Islands. The Cook Islands is still the gold standard to this day. And this is because it has so many statutory hurdles for someone has to jump through, and they have statutory non-recognition of any other jurisdictional court orders in the world, including the United States. There's statutory non-recognition. They'd have to start the case all over from scratch in the Cook Islands. They have to prove their case beyond a reasonable doubt. That's the murder standard, right? Like the highest legal standard in the world. They don't allow contingency fee attorneys. The complaints are not amendable like they are here in the US. And the great thing is the loser actually pays the legal fees, and they have to front the entire court cost, the person suing you. And there's only a 1-year statute of limitations. So generally, before they even know that the ball has been pitched across the plate, and strike three, they're out. Like, oh my gosh, I have to run down to the Cook Islands to sue this person. The statute of limitations is already ran. Now, when we compare this to the 4-part test, right? The Cook Island, the purely foreign trust, 5 out of 5 stars on effectiveness. So you don't get any stronger than that. But there are some drawbacks here. On the control side, you're going to be out of control because it's an offshore trust, right? Like the offshore trustee is going to be in control. Cost, they're going to be expensive, generally $50,000 if they're done right by a law firm. Compliance, a lot of IRS compliance, 1035, 1035As, back to disclosures. So while we literally have the most effective trust in the world by far, it's not something that we usually are starting out with. Less than 9.9% of our clients ever go purely foreign. We switch gears to the domestic side. They came about 10 years later. About 19 states in the US have some sort of spendthrift legislation one way or the other. One that doesn't, California, Oregon, Washington, they don't. So not all states have them. So that's one of the drawbacks here. Why were we doing this? Like, why were attorneys originally using domestic asset protection trusts in the US? One was just the cost. Straight up, they were cheaper, generally around $10,000 to $12,000 to set up. But the problem here is we started seeing courts come in, like, there's a Kilker versus Steelman case in 2012 that said, hey, we don't have self-settled spendthrift legislation, and so we're not recognizing other states' out-of-state asset protection trust. So while you can go to Nevada and create a Nevada asset protection trust, if you're a California resident, we're not recognizing it. And so we're starting to see a mess here, right? So what do people do? What are options? On one side, we have a trust that is way overkill for most people, highly expensive, but it's effective as heck, but most people don't need it. And then on the other hand, we're seeing an option where, it's cheaper, right? And I don't have to do the IRS filings. But sadly, it just doesn't work. And this is a lot of case law coming in. We got Bately versus Mortensen, In Ray Hubbard, Dale versus Dale, all really good cases. And unfortunately, the judges just didn't recognize the choice of law clause, completely pierced through all of those domestic trusts, and all the assets were lost 100%. So they're sadly just not effective. So what do we got? What are our options? This is where a hybrid option really comes into play. This is the third option of trust that we like to utilize, and these are called a bridge trust. What we're doing is combining the best of both worlds. You're taking the strength and power of the offshore component of statutory non-recognition, and then for the ease and domestic side of it, for IRS simplicity, we comply with IRS Code Section 7701, known as the court tested control test. And what this does, it allows the IRS, for tax purposes, to classify that strong foreign Cook Island trust as a domestic trust while we comply with it for tax purposes. So we don't have to file the 1035s and 1035As and no FACTA disclosures. So we get the best of both worlds options here. And so what that means is no IRS Form 3520, 3520As, no IRS FinCENs or FACTAs, no IRS filing requirements really whatsoever, as long as we're domestic. Assets can remain in the U.S. with your current bank. There's no requirements for a foreign trustee. They're just going to stay in standby until you ever need to utilize them. And then you maintain as the main trustee, and the trust is going to be completely tax neutral. And so this here allows us to have an effective trust. You're still going to be in control of your trust up until, like, God forbid, that point in time where you're getting sued and you're going to lose everything. Then you might not want to be in control at that point in time, which the hybrid trust allows. The costs are going to be more reasonable, and the compliance, there is none unless we actually have to trigger the trust and break the bridge and be purely foreign. And so that is all I have really for the asset protection side of things. And, I hope that this made sense. And again, don't try to memorize everything. Again, rewatch a lot of this and ask questions. And the book also goes over all of this with the examples and the case law as well.
Yeah. And Brian, thank you so much for sharing that, brother. And what I'll say, guys, just kind of echoing what Brian said here as well. Sorry, Zia is in the background. She's super happy back there. I was saying that Brian is the expert here. The goal isn't to turn you guys into asset protection attorneys in an hour. The goal is more so to give you guys some exposure to some of the different options that are out there. And I think maybe debunk some of the common myths that we hear when it comes to asset protection so that we can make smart choices as we build up our portfolios. But I also want you guys to recognize what Brian said at the beginning of the call, right? Like the sweater metaphor, right? Yeah. Where it's like, if you got one property, you don't need to go outside in a parka, right? Like you just need something light to kind of get you going, right? So don't overcomplicate it from the beginning either. There was one question here, and the guys will open up to the chat as well. This one was from Tanner. It said, are there any legal implications to living in one state, having a property in another, and then I'm assuming the holding LLC in Wyoming or Delaware? I feel like you kind of touched on this, but
yeah, I kind of beat that to a little bit. It's just like you have no legal nexus, and there's no point of running off to Wyoming because it's not going to benefit you in any way. You're just going to be basically paying more to maintain the Wyoming LLC and not get what you're actually setting it up for.
Right. All right. Okay, cool. Awesome, guys. We got time for maybe like one more question. So if anyone wants to come off of mute, ask a question, feel free to jump it in or drop it in. We'll get the recording. I did see that question from Renee and Jonathan. We'll put the presentation below this recording so you guys can go back and kind of click along as you're going through as well. But any other questions from an asset protection perspective for Brian here? Going once. Twice. All right. Awesome, Brian. Well, look, brother, we appreciate you hopping on, man. I know it's later on your side, as always. Appreciate you jumping on and spending some time with us. I think every time we go through this presentation, I feel like I learned a little bit more about the asset protection side. So, guys, if you want to get in touch with Brian, we'll make sure to share his contact info below as well. But, Brian, if there's any specific links you want to shoot over, just give that to Morgan as well, and she can make sure to post that here as well.
Yeah, just jump on my website, www.btblegal.com. I use it as an educational resource for y'all with a lot of frequently asked questions and media. And I break down a lot of the stuff also into like little like 1 minute, 2 minute shorts as well. Or just email me, brian@btblegal.com. Like I'd rather give you like an hour free consultation to get some good advice versus, getting run through the ringer.
Yeah. And I appreciate hearing that, Brian, because one of the things we always tell folks is like, guys, we can give you the story of how we've built our business, what we've done, but each person's situation is different. And the best way to figure that plan out is to talk to a professional. So obviously, guys, we bring Brian on because we got a lot of trust in what he does. So Brian, appreciate you as always, man. If I don't talk to you before the year's over, happy holidays. And we're looking forward to getting you on the call back here again soon, man.
Yeah, likewise. I'm going to spend mine in Belize on my honeymoon. So.
Oh, there you go.
Yeah, we
got mine here at home hosting
on
both sides. So it sounds like Belize is way more fun, man.
Yeah. All right, man. Take care.
Awesome.
Thank you.
Alpha hosts, have a good night, guys. We'll see you all next Tuesday. And enjoy the rest of your week, guys.